Welcome to Arb&Cast. Here, we talk arbitration and dispute resolution with worldwide professionals and experts. Our goals, opening frontiers, discovering different legal cultures, landscapes, and people. Today, with my colleague, Dalil Benmouffok, and myself, Adam Malek, we have the chance to interview not one, but two guests, Viktor Pasichnyk and Pavlo Lebediev.
Thanks, Adam. It's a pleasure to co-host. Victor, Pavlo, you respectively serve as associate and counsel at AGA Partners Law Firm in Ukraine. Your experience encompasses arbitration and dispute resolution in a variety of industries, but you have developed a unique expertise as a matter of commodities arbitration before leading in arbitration institutions such as GAFTA or FOSFA. Pavlo, Victor, thanks for joining us.
Thank you so much, guys. Dalil, Adam, it's a great pleasure to join this podcast. We would be happy to share our ideas, insights with you and with the audience.
Oh, thank you very much, guys. But first of all, could you please just let us know a little bit more about you two?
Yeah, sure. So we are lawyers from Ukraine, basically, and our core specialization is indeed commodities trade, and another core expertise of our law firm is shipping. This is a part of international trade because a predominant part of sale contracts, they're executed by sea. That's why these two industries, they are very interconnected. They are inevitably going hand by hand. And while we are representing clients in these transactions, sometimes disputes take place and they are going to arbitration. And as I said, we are originally a Ukrainian law firm, and we have been established 20 years ago when there were no global rules on the Ukrainian market. And since that time, we have developed this industry in Ukraine to the extent that I would say more than 90% of all contracts are now governed by these rules, GAFTA for grains and FOSFA for oils. But indeed, we have quite unusual, I would say, expertise because we are not Ukrainian law firm who works with Ukrainian law, but a bigger part of our job is to work with English law. And this is quite special situation because this is intersection of common law system and very special industry where there are unique rules, which I would say autonomous from English law, because GAFTA and FOSFA, these institutions, they develop their contracts and their rules. And that's why our expertise is intersection between English law and these unique rules. And at some point, we realized that there is a big demand from neighboring countries because Ukraine is not the only country which exports commodities, but also we saw the demand from Bulgaria, Romania, Turkey, Egypt. And we realized that we have a big advantage compared to other Ukrainian law firms because we can provide services not only to Ukrainian business, but also to international ones due to our expertise in English law. And because of that, we started to work on those markets. So basically, we started to export our services like Ukrainian producers export corn, wheat, and other commodities. In the same way, we exported our legal services. And I would say for the last 10 years, we have become one of the biggest, if not the biggest, provider of arbitration and trade services in this specific industry. Of course, it is niche industry, which is dedicated mainly to agricultural exports, but it is still a big percentage, around 10% roughly of global GAFTA and FOSFA arbitration cases. And at that point, we realized that we want to become a global law firm. We have such an ambition. And several our lawyers, we have applied for the solicitors exam to become solicitors in England and Wales, since this is the jurisdiction where all those gas and phosphor arbitration cases are taking place. And several our lawyers succeeded in becoming solicitors. And we hope to open office in the UK at some point. We are working hard on that matter. And that's why we are working really, really hard to realize this ambition. So this is in a nutshell about our law firm, about our expertise, about what we are doing on a daily basis.
Well, thank you very much, Pablo. That's very insightful. I think we will need to talk a little bit off the record, because I'm also considering becoming a solicitor, if it's okay with you.
Sure.
But I was not particularly aware, of the commodities landscape of commodities arbitration. So we are very glad to have you today on set, especially because topic of the podcast today is commodities arbitration, but with a little focus on the Black Sea region that you're master. So we believe you are more than perfectly suited for the job today with Arb&Cast. So thanks again for being here. Now, I think we can start with the questions, if it's okay with you guys, and I will give the floor to Dalil.
Thank you, Adam. So I'm very excited to start with this first question. The Black Sea region is a critical hub for global commodities exports, particularly in grain, oilseeds, and energy. From your experience, guys, what are the most common disputes arising in commodity trading in this region?
So I will start with general statistics of commodities arbitration, and then we'll pass the floor to Pavlo, who will outline our recent cases and our recent statistics for the 2024 year. So to start with, according to GAFTA official statistics, there are 301 cases in the previous year, and usually within the last 7 or 8 years, the number of such cases were between 250 and 400. 158 awards were rendered in GAFTA arbitration during the last year, so around half of cases settled and half of cases resulted in arbitration. GAFTA is the most popular forum for arbitrating commodities disputes because most contracts for sale of soft commodities, of grains, are contracts based on standard forms developed by GAFTA, which include GAFTA arbitration clauses. So around 80% of all grains worldwide are traded through GAFTA contracts, and almost 90% of all oilseeds, fats, and vegetable oils are traded worldwide under FOSPA contracts. So these two commodities trading organizations established in London, they play a crucial role, and they are like the critical arbitration hub for solving such disputes. The most popular disputes, they concern shipments of corn, wheat, and barley, predominantly of Ukrainian origin, as well as soybeans from India. Also, there are disputes with Canadian export and with export of commodities from the European Union, and we see a lot of such cases because we serve not only for Ukrainian clients and clients from the Black Sea, but we also work on cases related to Latin America, to Southeast China, and other countries. So our practice is quite global. According to statistics of GAFTA, more than $220 million were awarded in GAFTA arbitration during the last year. So an average awarded sum per dispute is around $1,400,000. So as you can understand, these disputes are not particularly large, but still there are a lot of such cases, and commodities arbitration form a line here of Ukrainian arbitration market. Moving to the statistics related to the type of disputes, according to GAFTA official statistics, more than 60% of cases arose from the default, from non-deliveries, non-acceptance, and other such like cases of non-performance of contracts. Around 19% were related to damage of vessels under contracts based on thief or FOB parity, and only around 10% of all cases concerned non-payment for the delivered goods. But our statistic differs, and I think Pavlo can emphasize particular types of cases that we see in Ukraine and in the Black Sea market, because these cases differ from the general picture and have their own peculiarities. Pavlo, please continue.
Yes, thank you, Victor. So I would like to give just a broader picture of the landscape of disputes in GAFTA and FOSFA. So what we have noticed within the last years is that there is a huge spike in the number of disputes. And there is a very clear reason for that. That's the Russian invasion into Ukraine. Because in 2021, there was a much lower number of disputes, because they were just dedicated to, they concerned ordinary disputes, like the quality of the goods are bad, some seller was not paid the full price, or the goods were not accepted. So some ordinary classic disputes which have always been in this market. But the Russian invasion changed really a lot, because in 2022, two large exporters of soft commodities were engaged into the war, while the entire world had really little stocks of those goods. So there was a real fear that there will be hunger, and because of that, different buyers from all over the world, they stopped to care about the prices. They started to buy various goods just to be sure that they have enough stocks in case there is a lack of commodities supplied to their countries. And because of that, the prices on the global markets, they skyrocketed. And this triggered lots of disputes, because in the end, was around 60 million metric tons of goods which were exported in 2021. Ukrainian suppliers had to deliver them somehow, and they could not do so because Ukrainian ports were blocked. So they somehow had to export them from different ports, from different countries. And this changed the entire logistical landscape in Ukraine. And because of that, many contracts were not performed. You simply could not ship the goods from Ukrainian ports. You had to deliver them to Romania, to Poland, to other countries. And all these economic circumstances, I would say economic and political, they influenced the performance of the contracts. Because of that, many suppliers could not just deliver the goods. Many of them declared force majeure, and this triggered a huge wave of disputes. And since 2022, we see that the number has not decreased. And what is also important, what we see from our practice, is that indeed the statistics which is provided by GAFTA, it reflects the global trends, and in particular our practice shows more or less the same figures. Indeed, around, I would say, 2/3 of disputes are about common defaults. When I say defaults, it means that someone have not supplied the goods, someone has not accepted the goods, so there is just straightforward refusal to perform the contract. Of course, sometimes the parties, they develop different excuses for those actions, for that conduct. And from those circumstances, we see different arguments like there was a force majeure, there was a frustration of the contract, or we have not concluded a contract at all, because in GAFTA and phosphate trading, most contracts, they're concluded in WhatsApp. So it's just enough for traders to commit themselves to a transaction. And just recently, we had a very unusual case where GAFTA tribunal confirmed that the contract was concluded in an oral conversation. And it was a very interesting case because it was very difficult to prove that there was indeed an agreement while you didn't have any confirmations in writing. But that's the reality of commodities trading. You have to be very flexible because the market is going up and down very fast. For example, while we have been talking for these 20 minutes, I would say, the price could have changed, and the offer which I would make to you 20 minutes ago might be different now. And because of that, we see there are lots of disputes connected with the contract conclusion. And that's also a major part of the disputes. Other categories are quite usual, like quality of the goods, demurrage, which means that the vessel or some trucks, some rail cars, they were not loaded or discharged on time, and that's why they were just idling. But those are just ordinary disputes, which I would say they take place in almost every industry. It's not something very special for commodities trade or for Black Sea region.
Well, thank you very much, guys, for this insightful answer. Pavlo, you just said that, and I'm trying to quote, that you need to be very flexible in the commodity markets. But is there anything you can rely on? I mean, you mentioned GAFTA, FOSFA. Are there default mechanisms for resolving disputes? Does commodity arbitration know any default mechanism for resolving disputes? And how do these institutions address the unique risks and challenges of commodities trading?
Yeah, sure. So there are default arbitration clauses, and I think Viktor would help me with that question. Viktor, please go ahead.
Okay. So GAFTA and FOSFA, as well as many other such like institutions specialized on other commodities, they are not like ordinary arbitral institutions. So they offer not only arbitration services or other alternative dispute resolution services, but also standard contracts, standards for analysis of the goods, for surveys, for fumigation. They offer educational courses for traders. They conduct a lot of conferences and events. So it's an entire ecosystem that satisfy like all needs of traders. And because of that, GAFTA and FOSFA took their leading role in the commodities arbitration market because they promote their standard contracts worldwide, and traders who adopt their standard contracts or who incorporate them in their more tailor-made contracts, they commit themselves to resolving disputes under GAFTA or FOSFA rules. So moving to the peculiarities of GAFTA arbitration and FOSFA arbitration, these institutions have a closed list of arbitrators. So you cannot appoint any arbitrator who is not included in this list. And this arbitration is quite, let's say, back to the roots. So most of arbitrators are experienced traders who consider disputes between other traders. And practicing lawyers from law firms are expressly prohibited from assuming the role of arbitrator, and they cannot be included in this list of arbitrators. This is so to decrease the time needed to consider like all legal arguments in detail, and to provide more industrial expertise to traders, because those who have like 20 years of experience in grain trade, they have better understanding of how this works, and in general can resolve disputes faster and sometimes in a more just and commercial manner than the lawyers can do. Also, these arbitrations are relatively fast and relatively cheap. Average duration of GAFTA or FOSTA arbitration is between 7 and 9 months, and average cost is between 15 and 20,000 British pounds. So it's really cheap and fast and suit the needs of commodities traders and agricultural companies. Another important feature is an appeal arbitration. This makes GAFTA and FOSTA quite unique, because if you are not satisfied with an award rendered by the first tier tribunal, you can appeal this award before the Board of Appeal, consisting of 5 arbitrators, which hear this appeal orally, and the parties in the appeal arbitration, unlike in the first tier arbitration, where the dispute considered only based on the parties' submissions without oral hearings, in appeal arbitration, the parties submit only very concise statement of cases and deliver most of their arguments orally, like within 1 or 2 days, in which hearings are held. Another peculiarity is that practicing lawyers are prohibited from representing parties in the oral hearings in appeal. So the parties engage trade representatives. Usually, such trade representatives are GAFTA and FOSTA arbitrators, but sometimes the parties can be represented by their own traders or sales or chief operations officers and other C-suite executives, or some experienced traders who are not their employees, whom they involve to represent their interests in appeal. Okay, so moving to the statistics, in the last year there was 52 appeal awards, and around 25 of all awards rendered by the first tier tribunal under GAFTA rules were appealed. Appeal took like from 10 months to a year to be completed, and it usually costs around 25 to 30,000 British pounds. So again, it's relatively cheap. And even if you have the first tier arbitration and then the appeal, it usually takes no more than 2 years to obtain an enforceable and final award. Another interesting feature is that submissions the parties submit in such arbitration are usually relatively brief, like from 8 or 9 pages to 35 pages. And very rarely we see some extensive submissions and many rounds of submissions. So the proceedings are quite fast and quite focused on commercial things. So there are cases, of course, where we see some debate over legal issues. But in most cases, the parties rely on more commercial arguments and do not dive deep into the legal part, because most disputes are concern facts, not some differences in interpretation of legal provisions. Also, the proceedings are conducted in quite, let's say, informal manner. So there are no formal procedural orders. Arbitrators just send the parties letters requiring them to submit submissions by certain days. And quite often such deadlines are extended, so the proceedings are quite flexible, and arbitrators understand the issues the parties face. For example, in Ukraine-related arbitrations, we have many cases in which we have seen such extensions. So the procedure is really tailored to the needs and problems of traders. Important feature of GAFTA and FOSPA arbitrations is the list of defaulters. As I have mentioned earlier, around 80 to 90% of all soft commodities trades is going through GAFTA and FOSPA, so they have an opportunity to establish rules and to punish those who violate them. And they have lists of companies who do not comply with arbitral awards voluntarily. And this is quite effective instrument in practice, because in most cases, the parties comply with arbitral awards and pay the money quite quickly without trying to set aside the award or to undermine its enforcement, because they are afraid of reputational risk. If the party is included in this list, its potential counterparties may decide not to enter into contract because they understand that if something will go wrong, and it's quite usual situation, because there are a lot of commodities arbitrations and a lot of disputes due to fluctuation of prices, as Pavlo said. And this creates pressure on parties to comply with arbitral awards. According to statistics of GAFTA, 37 companies were posted in this list within the last year. It's around 23% of arbitral awards that were rendered. So we may draw a conclusion that only in around 1/3 maybe cases there are an enforcement, but in most cases the parties pay the sums to creditors under awards rendered in GAFTA and FOSPA arbitration. In the Black Sea market, we see a slightly different situation, because the parties are more tough. They not always want to comply with awards voluntarily and try to play for time and undermine enforcement force. So this mechanism may be not so effective, but still it works. And we have seen less enforcement than in other arbitrations, like, for example, LCA or Ukrainian Arbitration Center. As to the particular peculiarities of dealing with default, standard contracts developed by GAFTA and FOSPA, they have a default clause, which allows the innocent party to for one of two options of calculating the default damages. The first option is to resell the goods to an alternative buyer and make the notice that we are selling the goods against the defaulter. And after that, the innocent party could claim the difference between the contractual price and the price under the resale contract. Another option is to calculate damages based on the difference between the contractual price and the market price, which is usually confirmed by a market price attestation produced by commodities brokers and sometimes by agri-analytical agencies, although commodities brokers generally have a better reputation and arbitrators value their attestation more. Moving to some unique challenges GAFTA and FOSFA address in the Black Sea region, we should mention that they have developed a standard contract for Ukrainian exports based on FTA and CPT parity. We have participated in this process, and like our company have drafted this contract in cooperation with GAFTA. It's GAFTA 78 UA contract. And GAFTA also have as well as FOSFA special contracts for some countries or regions that took into account peculiarities of trade in these countries. For example, they have contracts for Canada, for Australia, for India, for China, and for some other countries that are based on some practical manner of doing business in these countries of exporting goods. So I think that's all. Maybe Pavlo has something to add.
Yes, sure. So for our listeners, I would tell a story about my university years. When I was pursuing my LLM in Stockholm, ICAL program, we had really extensive discussions how arbitration can be autonomous from legal systems to develop a really unique system where you can get an award and get it enforced. And when I started to practice commodities arbitration, I realized that they are really close to this kind of a system. Why? Because they have not only arbitration itself. They do not provide only the arbitration services, but they also created kind of an ecosystem of contracts, of people who know how to check the quality of the goods. They have traders who are resolving disputes. They have various rules on fumigation, on survey, on laboratories. So in the end, they provide the traders with everything they need to work in this globalized world. And if the trader values reputation, they will be really ashamed of becoming a part of defaulters list. So this kind of a blacklist. And this unique feature that there is some a list where you see who did not perform the award makes them enforce it even without going to the courts. And this enforcement mechanism is unique compared to other arbitral institutions which do not specialize in one particular field. Of course, they might have some kind of disputes which is predominant in their practice, but still they do not unite the traders in one specific industry. And this is a very interesting feature. So from my perspective, for those practitioners who specialize in arbitration. And another, I would say, striking and at some point an astonishing feature is really that the lawyers, they cannot participate in the hearings. Can you imagine that you are not allowed to just to come to the hearing and listen to the arguments? This is something really out of my mind. It was out of my mind at the point when I started to practice GAFTA and FOSFA arbitration, because I thought, why is it happening? So what's the matter with you? But in the end, what I was told by different traders who practice GAFTA arbitration, they told me that, look, this is just a traditional thing for English arbitration cases, because 100 years ago, the counsel, he or she had to present the evidence like by their hands to show why this or that goods is not good. And because of that, they developed this rule, and it remains up to this date. And I would say in 2024, we had a discussion with Director General of GAFTA, and they remain their stances. So they say, this is the rule. We want GAFTA to be for traders, not for lawyers. And they still have this rule. And I would expect that it won't change in the nearest future. Because in the end, they don't want to complicate things. Really, in this kind of commodity arbitration, and I would say in shipping arbitration as well, the substance is more important than the form. So you won't go deep into some legal arguments, interpretation of laws, statutes. You need to show the case, because the guys who are in the arbitral board, they are usually simply not lawyers. They might not comprehensively understand all those legal peculiarities. But what they want to hear from you is, what is your real commercial position? Tell me, why did you bother about this quality? Or why did not you perform the contract? What's the problem with force majeure? So they're going in the essence of the problem. And this is very special for GAFTA FOSFA arbitration, because we still have LCA, SEC arbitration cases. And we see that those cases in those institutions, they are more formalized. And this makes GAFTA and FOSFA much more different. It is really, I would say, one of the reasons why not that many law firms practice this area, because you need to have not only understanding of English law. So basically, when you come to the arbitrators, you really need to walk in their shoes. So you need to understand that this is the arbitrator who has experience in trade, in survey, in shipping, but not in law. And you need to explain your position to them in commercial words. Of course, you need legal grounds and legal position to support this or that argument. But in the first place, you need to be commercial. You need to understand the rationale behind the decision of the client. And this also makes the difference in your communication with the client, because while in most LCA, SEC, other big arbitral institutions, you work with legal teams. In our industry, our main contact person is the trader, who explains the economic position, who shows why this contract could be performed or not. And we as lawyers, we sometimes feel to be traders as well, I would say, because you need to really change your mindset when you practice this particular area. And as I said, I feel that it is one of the reasons why not many law firms are present in this market, because in the end, you need a quite different expertise compared to what you need, for example, in construction, energy, or investment arbitration. And on the other hand, we also understand that that many lawyers, they cannot just get this kind of information from web pages, because this is arbitration. And the information is quite closed. Of course, FOSFA publishes the anonymized words, but this is really a small part of decisions which we see in practice. So you cannot do it without understanding the internal kitchen of those arbitrations, but on the other hand, you cannot get it because you don't practice. So it's kind of a vicious circle for them. And final comment, which is also interesting for the practitioners, is that in the end, it is not only the complexity, but the speed of providing services, because the market is moving up and down every 15 minutes, every hour. You need to provide your expertise and provide your advice to the client instantly. You don't have time saying, look, I will take one day to check all the contracts. I will check the precedents and then come back to you. No, it is not working like that in this field. You need to give instantly the answers, because the trader then will take your answer as a basis of his or her commercial decisions. And that's why you really need to have this expertise, and you don't have much time to prepare, to comment. And this is quite unusual, I would say, compared to other industries where you have more time, where you have time to develop a very detailed legal position supported with various legal authorities. This is not the case for GAFTA force fine shipping arbitration.
Thank you very much, guys, for this very broad answer. Very complete, I would say. There still leaves another big question. Why are there so many disputes in soft commodities trading?
Well, I can handle this question. I would say that the reason is exactly what I've said in my previous answer. That's the volatility of the market. So when, let's imagine I'm your seller, you are my buyer. And I sell to you, let us say, I don't know, for a French wheat, okay, for $200 US per metric ton. And this is the price today. Tomorrow, because of the tariffs, because of which American president has imposed, because of the general trends on the market, the price has gone up for, let us say, $10. And if it is like more or less big parcel, a Panamax vessel, the difference, the damages can be 500,000. So that's the price which the traders would fight for. And they would fight for this amount, not only because they want this money, but because it's the matter of prestige and to show that my contracts must be honored. Otherwise, I will go to arbitration. So the volatility of the market creates various issues for the traders, for the market participants. And that's why we see that the number of disputes is much bigger compared even to other commodities like coal or oil or any other commodity which you might find on the market. That's the main reason, I would say, because it's just the economy, it's just commercial side which explains things. Another reason, which I would say also important, is because there are really various players on the market. So it's not the industry where you have monopoly of like, let us say, Fortune 500 and that's it. You have only those companies. Now, on the global commodities market, especially in agricultural industry, you have thousands of companies, from really the smallest ones where the farmer can sell to a trader to really huge multinational companies. And when you have different options, you don't have the fear and the obstacle that if you breach the contract, if you do not supply the goods, then you can go to someone else. You have this option. So you breach this contract and then you go to a different trader, you sell these goods to another one for a more favorable price. And because of that, you don't have this really strong bond between companies. Of course, like long-standing players who have partners in the market, they might have those bonds. But if we are talking about the general market trends, they are not that close. The companies are not that close, and they have the option to consider defaulting, paying some compensation, or not paying this compensation. And then this creates prerequisites. I would say it creates a favorable ground in speaking of agriculture for disputes. And finally, this is not the major reason, I would say, but still it's an important one. It's the culture, because arbitration is not the dispute resolution itself. I would say it's just like the prolongation of the trade contract. So the parties they don't feel that they are going into a very ugly arbitration and they have lots of problems. It's just like a regular thing that they do more or less on everyday basis. So if you don't have the performance of the contract, you go to arbitration. And this is supported by GAFTA itself, who has this defaulters list, this kind of blacklist, and circulates it on the market. So you understand that even if you have some company which doesn't have assets to fight for, you still will have a reputational damage. You will cause reputational damage to this company. And that's why the companies, they just tend to fight in arbitration. And they once they have one case, they understand the peculiarities, they understand that it is relatively cheap and fast, they become more inclined to fight for another sum in another dispute. So I would say these three criteria, that's the volatility of the market, the big number of players on it, and the part of the culture which caused that big number of disputes.
Thank you, Pavlo. And I have the chance to ask you guys the last question of this podcast. So, please, can you tell us and speak a little bit about, the geopolitical landscape in the region with this question, which is, given the geopolitical tensions and shifting regulatory landscapes in Ukraine, and of course the wider Black Sea region, how have arbitration trends evolved?
So I will address this question. I will start with stating quite obvious thing that the chief factor influencing the region, besides some global trends, is the war in Ukraine. It caused a lot of problems for Ukrainian traders. It also caused some problems for Russian traders. It created some opportunities for traders from other countries, and it transformed the way how the contracts are performed in many aspects. So to start with, now Ukrainian exporters have more complicated logistics because they are not exporting goods only through traditional Black Sea ports, which are very large and suitable for exporting the goods through Panamax vessel, through large ships, and they are forced to trade through smaller Ukrainian ports and through ports of Romania, let's say, of Poland, other countries. So this makes, first of all, the logistical chain, the supply chain, more complicated and more opportunities to have a dispute arise because more parties are involved, and the route the goods are passing through is longer. The second thing is that combined with quite low current market for grains, this creates quite a hard situation for Ukrainian exporters, and they fight for every dollar, for every cent. So they are more inclined to go to arbitration in cases where previously, before the war, they would decide that it is not worth it. So more disputes arise from small contracts, from contracts under which the sellers from Ukraine have a relatively weak legal position. Another thing is sanctions. Sanctions again influence trade in multiple ways. First of all, Ukrainian government is hunting for vessels which violate the sanction regime of Ukraine, and they try to arrest vessels and commence criminal proceedings against ship owners, against masters and crews of such vessels. which go to Crimea or to other ports like Azov Sea, which are occupied by Russia. And this creates problems for traders because we had cases where the vessel was arrested and the goods were took hostage, and it was quite hard to free them from this vessel and to allow the seller or the buyer to continue with the contract to perform it. Another aspect of sanctions is that traders may rely on them in a bad faith, alleging based on some rumors, on some unreliable information that their counterparty is sanctioned or may be related with some sanctioned individuals or entities, or export goods to some sanctioned country like Iran, for example. We have seen quite a lot of such cases. Another thing is restrictions imposed by Ukrainian government. First of all, it's the payment, cross-border payment restrictions. It's quite hard to pay for the goods from Ukraine or to comply with an arbitral award by paying the money from Ukraine. Although this is not an issue for most traders because they are incorporated in Switzerland, Dubai, in Cyprus, in some offshore countries, or maybe in England. But still, it's a problem for contracts with small or mid-sized Ukrainian farmers, which do not have like a foreign legal entity to pay from it. And we have seen a lot of cases where the parties tried to find some way to perform the arbitral award, even if the debtor wants to perform it, by finding a way to bypass this restriction. Another thing is campaign of Ukrainian government against so-called gray export of grain, against tax evasion schemes employed by some traders. Because of that, we have searches in ports. We have problems with obtaining clearance for export from customs. And because of that, the vessel may idle quite a long time, for several weeks or even a month. And this leads to default because the sellers cannot comply with the shipment period. And this also leads with disputes not only between the parties of the sale contract, but also under the charter parties, between the charterer, who may be a seller under his contract or a buyer under a FOB contract, and the shipowner. Another factor is restrictions imposed by some other countries in the Black Sea region. For example, Turkey imposed import ban on wheat in like most years during the recent time, and this creates problems with exporting grain, exporting wheat to Turkey, because it's one of the main importers of Ukrainian grain, and we have a lot of Turkish clients, a lot of clients selling grain to Turkey. And like the third trend is market price fluctuation caused by some political factors, by escalation of war, by sanctions, by some decisions of large countries such as USA or China. And if these restrictions are quite significant for grain market, they are even more tremendous for the vegetable oils market, because it may be a difference of $200 or $300 per metric ton for sunflower oil, for example. And because of that, there are a lot of disputes with significant money at stake that arise out of such fluctuations. Another trend which maybe we have not yet seen in full, is trade wars, is imposition of some tariffs or quotas for imports by the United States of America, because the current presidential administration likes this instrument and tries to ban imports of some soft commodities to the United States. And this caused a chain reaction, because other countries who trade with the United States also impose their limitations. And this can influence even the trade in the Black Sea market, because it depends on the global market, and because like European countries may review their approach to importing goods from Ukraine and from other countries in the region, for example, Turkey. And the same concerns countries of the Middle East and South Africa, which are also important buyers of goods from Ukraine, from Turkey, from other Black Sea countries. So even if we have not yet witnessed a lot of disputes arising out of this, we expect to see them soon, because like these factors may aggravate each other and may disrupt the trade as we know it now. I think that's all, and Pavlo could share his thoughts on exodus of Russian traders from GAFTA and FOSFA contracts, and their reliance on other arbitral institutions like Dubai International Arbitration Center and Singapore and Hong Kong arbitration centers. I think it's quite an interesting trend, and there is a chance that other countries may follow this path.
Yeah, I totally agree with you, Viktor, in terms of the fact that all those political tensions, they gravely affect our practice and international trade in general, because there are so many events that change the way how the contracts are performed. Starting with the Russian invasion especially, it started, all those disputes that we are handling, they cease to be quite straightforward. There are various sophisticated legal instruments, like maybe you have heard of grain deal between the UN, Turkey, Ukraine and the Russian Federation, which established a unique legal instruments how the goods were exported from Ukraine. Afterwards, there was an earthquake in Turkey, there were import restrictions in Turkey, then trade wars which the American president has started. And these political events, they inevitably affect how the trade is done, and this quite often prevents the companies from performing the contract, and this creates lots of triggers for disputes. And this is why, as I said in the beginning of our conversation, the number of disputes have increased dramatically since 2021. And as to the final point which we would like to share is that we see that quite often Russian traders and their counterparties, they tend to refuse to provide for the GAFTA or FOSFA arbitration clause in their contracts, because there are regulations in Russia saying that those GAFTA and FOSFA awards might not be enforced in Russia because those countries are not friendly to them. And because of this trend, there are certain countries contracts which provide for different institutions in more, let us say, neutral countries like Singapore or Dubai, and that's why they try to get away from English-based arbitral institutions. Nonetheless, or I would say that it might be quite a limited scope because the counterparties like Turkish, Egyptian, like Asian buyers of Russian grains, they might be concerned by this fact because this is not customary on the market. So these are quite new initiatives. So that's why we will still see how this trend will develop. Nonetheless, we definitely see it, and it might change the landscape and the more regionalized approach to grain trading and resolution of disputes in this field. So that's more or less all from my side.
Well, Pavlo, Viktor, thanks a lot for all your answers. Personally, I learned a lot from you today because I was not particularly aware of commodities arbitration, especially in the Black Sea region. I will not speak for Dalil, but I think he agrees with me. So thanks a lot. We are pretty sure that our listeners will definitely enjoy the talk of today. Thanks again, guys.
Thank you. Thank you. It was a real pleasure to join your podcast.